Good morning, everybody. Welcome back to Lateral Lawyers podcast. It's been a while, really busy, which is great. Always want to keep good content coming out to help the viewers, and what better way than to start this mild Auckland Monday morning than with a little treatise, is probably being a bit kind to myself, but a little rundown on how to manage a situation where you are potentially going to be in dispute. Because for those of you who haven't been in a long, drawn-out legal wrangle, being in dispute is a very stressful, time-consuming, expensive process that you don't want to take the decision to enter into lightly. So what I mean by that is it's a bit like a chess game. You've got to figure out as far in advance as possible whether or not you have the stones to proceed down that route. And the job of someone like myself or my friend Chris Patterson across the corridor, who's a very experienced gun litigator, is to give you a proper rundown of that cost-benefit analysis at the inception of the dispute. I'm just going to run you through a quick example. It's a bit of a, how do I put it? It's a little bit of a collage of various dispute type situations that we've advised on lately. Obviously, no names will be mentioned, and it'll be sufficiently patched together from different circumstances so that no one will know what we're talking about here. So, without further ado, we've got a situation where you have signed a residential sale and purchase agreement to purchase a fee simple, so freehold property. The LIM has an entry on there about a building consent that was applied for after 1992, so when the New Building Act applied, and there has been there is a notation that there is a CCC that needs to be granted, and you've been advised by the real estate agent that that CCC has indeed issued, but the LIM has not yet been updated. You, on that basis, and possibly you didn't receive legal advice prior to attending the auction, you bid at the auction and you win the auction. You then engage your lawyer. Your lawyer looks at the LIM and advises you that there is no CCC that has been issued. Indeed, this representation that the CCC had issued and the LIM had not yet been updated was in fact incorrect. Now, you're not sure whether or not it was intentional, but the fact is that the dwelling now lacks a CCC. This is what we would call a misrepresentation. Misrepresentation is a representation of the facts, position regarding a matter which is not true. Now, there is complexity around whether or not a given misrepresentation is sufficiently serious to allow for cancellation, termination of the contract, return of a deposit if it's paid. That's not a simple matter, and I'm not going to explore that today. And of course, this isn't a forum where we give specific legal advice. You'll need to come and see us if you want that. But I'm just trying to furnish as much information out into the public forum as possible, so that people are as well armed as possible before they go and purchase properties. So in that situation, you'll talk to your lawyer, and your lawyer will work you through what we call the test for misrepresentation, and then figure out your options. Let's just assume, for the sake of this example, this little work through, that the lawyer advises you that it is sufficiently serious that you would have plausible grounds for a termination of the agreement. First of all, there is the cost risk. So if you're going to get a competent lawyer to write to the vendor's solicitor and work through all of the legal points of the test, which your lawyer has from which your lawyer has formed the view that the misrepresentation is capable of terminating the contract on your behalf, you better be damn sure that you're right about this, because if you try to terminate the contract pursuant to this misrepresentation, and you are in fact incorrect, that's called a repudiation of the contract. And in layperson's terms, you've given away or given up on your obligations under the contract without a proper basis to do so. And significant damages or specific performance, i.e. being forced by the court to actually complete the transaction, can follow a repudiation. So you get into a situation where you get proper advice and you get it right as to whether or not you have a proper basis to terminate the contract. Cost, though, that might cost 2, 3, 4, 7, 10,000 just to go through that process and then have the first series of back and forwards with the vendor's lawyer. And Siri's turning on. Said I'm listening. With their lawyer, or they might bring in a specialist, a barrister, to really put the blowtorch on you if you're trying to, from the vendor's perspective, weasel your way out of the contract. So you need to be careful that you've got a proper basis, and that's going to cost you. Then, excuse me, if you're going to go down the path of continuing to fight the vendor over whether or not you had a proper basis and the proper consequence that should flow from that, you're going to have to dig in for another 10, 20, 30, and then potentially hundreds of thousands if the property indeed is worth millions and millions and you really want to dig your toes in and the vendor really wants to dig their toes in, that's going to be a super expensive process to go through. So what you need to do, you and your lawyer need to figure out when you sit down, if you're going to start a dispute over something serious like this, you need to figure out as much as possible, or project as much as possible, what the likely next move of your opponent, in this case the vendor and potentially the agent, are. And then you need to figure out whether or not you have the financial wherewithal, but also something that really gets overlooked often, the emotional wherewithal and the time. Because those two components, the emotional wherewithal and the time, they really drain you from family life. They drain you from obviously your financial resources, but also being able to focus if you're in business yourself, or you've got a good job and you need to perform well in that job to earn an income for yourself or your family. You need to make sure that you are not being really drained from your normal life by this thing going on in the background. So that is an enormous cost that often doesn't get factored in by people when they are embarking down the path of bringing on a dispute. All right, guys. Well, I hope that was somewhat helpful. Of course, nothing in here is specific advice. And, if you do have an actual specific query, come and give me a shout out on Facebook Messenger, or check out www.lateralllawyers.co.nz or www.propertylegals.co.nz. Me and my team, we'll be real quick on the draw to come and figure out what, to bounce some ideas off you before you engage it as to whether or not you should go down that path. It is really tricky. It needs to be thought out as much as possible in advance of being in that situation. And look, to be completely frank with you, just come and see someone like us before you even, at the gestation stage, the idea stage of going to buy a house or going to buy a business or entering into a lease. Come and see us when you're just thinking about it, because you might spend $300 or $500 or $1,000 with some advice, but with that advice will come the checks of the contract, but also checking in terms of where you're at and what your appetite for risk and how to cover that off. Even if it costs you a little bit more at the start, or something at the start, you're going to be in a damn sight better position than going into this transaction with your eyes shut and then having to come to us and probably pay someone like us a lot more money to try and pull yourself out of something where if you'd had proper advice and you'd followed a proper process in the first place, you wouldn't be in trouble. So cheers, everybody. Have a great Monday. And I look forward to seeing you again online soon. Cheers.